Please be seated. We'll hear argument in 22-1023, the City of Denton against Grimm.
The court, Mr. Kratovil will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, Chris Kratovil with my law partner, Allison Ashmore, on behalf of the petitioners in this matter, the City of Denton, Texas. Your Honors, this case presents a straightforward question of statutory interpretation. The statute at issue is the Texas Whistleblower Act, which is found at Section 554 of the Government Code. The positive question before this court is whether the Whistleblower Act applies to the actions of a single member of a 7-member city council when that elected council person, who's also unpaid, acted without the knowledge, approval, consent, or subsequent ratification of the council. In other words, in interpreting the plain language of the Whistleblower Act, is a single rogue council member the same thing as the employing governmental entity? Now, the court below, the Dallas Court of Appeals, has answered this question yes, and the respondents today urge this court to do the same and to extend this rule to the entire state. But to do so would do violence to the plain statutory language of Texas Government Code Section 554.002A and would represent a material judicial expansion of the plain words of the legislature.
If the city council had passed a resolution that said, okay, this member is going to handle this sort of thing, and this member is going to handle this sort of thing, and this member is going to do this other thing, and then you go out and you're doing that thing, in that kind of a situation, are you acting on behalf of the entity?
I believe you are, Your Honor. In that scenario, Texas cases are legion that multi-member boards, whether it's at the county level, the municipal level, special district level, where there's a multi-member board, it's the actions of the majority of the multi-member board that are the acts of the governmental entity. And certainly the Denton City Council could have, by a 4-3 vote, empowered this individual council member to act with authority for the entire council on a particular issue or in response to particular requests for information. That did not happen here. Quite the opposite.
You're not contending that an elected official can never act for the employing governmental entity, just that it didn't happen here.
Yes, Your Honor, that is correct. There are scenarios.
A city can't act without people acting for it, right?
Absolutely, and that's why the Government Code, the Whistleblower Act, specifies that an appointed officer or an employee is covered. It's another public employee, and then there's a definition.
But an elected official could also be covered.
In circumstances
were, like in Justice Blacklock's hypothetical, or
exactly.
We have courts of appeals that have individual rules where one judge can act for the Court of Appeals, even though it's the whole court. And so, if God forbid a judge took a bribe and was acting as one judge for the whole Court of Appeals, and somebody reported that, you wouldn't say, "Oh, well, you can't take advantage of the Whistleblower Act because that was just one judge."
Justice Busby, you're exactly correct. If the multi-member board sets up a rule or delegates authority or passes a resolution to empower an individual member to take actions, those are the acts of the city or other local governmental entity.
Or even if there was a practice of doing that, would you say it would be the same?
I think that would be closer to the line and closer to the statutory definition we're dealing with here. But I can certainly envision scenarios where you have an executive as opposed to a legislative officer who acts, and where an executive or perhaps even a judicial officer acts, I could see that being covered. The difference here, it's really a separation of powers issue, Justice Busby. A city council exercises legislative power that's been entrusted to it by the state of Texas, by the Texas legislature. So they're exercising a little slice of the legislative power of the Texas legislature. And just as if one member of the 150-member Texas House or one member of the 30-member Texas Senate were to act, that's not an act of the House, that's not an act of the Senate. This was not an act of the Denton City Council, and by extension, not an act of the city of Denton.
Well, it seems, though, that they're, like, for example, with a court, everybody's under a general obligation of confidentiality. And if an employee of the court says, reports that somebody has breached that obligation of confidentiality and, then is fired in retaliation for making that report. Would you say the Whistleblower Act applies in that kind of a case, but not in this case?
Well-
Because the employee was not directly employed by the city council?
So, Your Honor, I think it goes back to the statutory language of 554.002A, where the second part is another public employee. That would be covered under the plain language of the statute as another public employee. So if court employee A reports court employee B for a violation of the court's confidentiality provision, that is very much within the plain language of the statute. That's not the scenario that we have here. We have a volunteer, unpaid, elected official who my friends on the other side don't even contend is another public employee. So once we're out of another public employee under that statutory definition, and I think that statutory definition captures the vast majority of the situations in which the Whistleblower Act could apply, because there's almost always going to be another public employee
The
involved.
difference here is not so much that she's a single member of a multi-member body, but that as a single member, she was a volunteer.
She's unpaid and she's elected. The statute talks about employees and defines employees as those receiving pay. So she's out as an employee, and they've never contested that. And then all that is left is if the violation is by the employing governmental entity itself. And this court has recently, within the last year, in the Pope case from last May, dealt with that by saying very explicitly the misconduct needs to be by the employing governmental entity. In that case, it was deemed insufficient that an independent contractor working for a state department, that a reported violation by the independent contractor would be covered by the act, even though the respondent in that case argued that it was implicitly an act of the government employee. I think this case is kind of a natural companion to Pope. Pope dealt with independent contractors. This case deals with unpaid elected officials who are just not encompassed by these very helpful statutory definitions in 554.001.
What about the fact that these volunteers in this situation have a lot of influence over the employees who are actually going to do the termination? How does that play into all of this?
And that gets into the second half of my argument, which is legal sufficiency of the evidence. But Denton is a city manager form of government. Council manager form of government. The city manager is the chief executive of the city and is empowered to make the hiring and firing decisions. Here, the city manager, Mr. Heilman, signed on, was new after the report of the misconduct by these respondents. There was an almost year-long gap between their report and their termination. Mr. Heilman, the city manager, was hired during that time, and his testimony and that of his assistant, Mr. Langley, was that they carried out the termination. It was not carried out by the council, and there's no affirmative evidence the council was involved.
So would your argument be different if that were not the case? Let's say if the person who's in this volunteer capacity, and we see it all over the place all the time, and those people who aren't actually employees of the entity, whatever it is, that is actually terminating the person, but still, those people in those positions have a lot of influence.
Yeah. In that scenario, Judge, I think we're, again, looped back to another public employee. If the city manager is a public employee, right, the city attorney is a public employee, their respective assistant city managers and assistant city attorneys are public employees. If they are compelled to terminate somebody, and that's not what this record supports, then arguably the act would apply because another public employee is involved. Here, there's not another public employee involved. The only argument has ever been that the actions of this individual city council person, elected and unpaid, not an employee, not an appointed officer, are synonymous with, equivalent to, the same thing as the actions of the city of Denton itself. And that just can't be right under Texas law, because we know from decades, almost a century of Texas case law, that cities, counties, and other local governmental entities act through the majority votes of their governing boards.
So some of the cases here look at various factors. One that they look at is whether the person was acting in an official or unofficial capacity, and that seems helpful. But another one they look at is whether the action was authorized or unauthorized. And I'm not sure that's helpful when you're dealing with a whistleblower statute where you're reporting a violation of law that is by definition unauthorized.
Well, I think there are scenarios, and Pope from last May was one of those scenarios where the unauthorized act could benefit the city could ratify it, the city could accept the benefits of the unauthorized act. That's the diametric opposite, Justice Busby, of what happened here, where as soon as the city learned of this alleged violation by Councilmember Briggs, the city attorney wrote her a memo saying, my office can't help you. You need to retain counsel of your own. You need to pay for that counsel of your own. There is now adversity between you and the city of Denton. So far from embracing Ms. Briggs' actions, the city didn't ratify it. It immediately, upon learning of it, distanced from it. And Kilgore, Your Honors, I think what the Dallas Court of Appeals has done here, and Justice Mohlberg wrote the majority opinion, there's a really fine dissent from Justice Peterson that I would ask the court to take a careful look at, is to say that the definitions in the Whistleblower Act, as articulated by the legislature, are inadequate, and that if something relates to a person's duties, or if it is in the public interest, then the Whistleblower Act covers that. That's just not what the Whistleblower Act says. If you look at its statutory terms and statutory definitions, the Dallas Court of Appeals has taken it upon itself to broaden that act. And there may be valid policy arguments for that, but those policy arguments need to be made over there under that pink dome and not in the Dallas Court of Appeals courtroom.
We're trying to come up with a rule, a general rule that courts can look at to say, when are the acts of somebody like this to be attributed to the city? Would it make sense for that rule to be something like, if it's an official act of the officer that's within the authority of that officer that violates the law, then that is going to be considered an act of the entity?
I think that's a viable definition, Justice Busby. If someone, particularly an executive, is acting within their capacity, that can be an act of the local governmental entity. Here,
if it's within their authority and it's an official act.
Absolutely, Justice Busby.
Okay.
Your Honor articulated it better than I possibly could. And that's why I refer to this really as a simple exercise in statutory construction. Because the legislature has provided us with viable definitions in this statute. And I think this is a three-step process to see if the statute applies here. Step one, this is a waiver of sovereign immunity. The legislature has exposed local governments to suit under limited circumstances via the Whistleblower Act. This court for decades has held that where there's a waiver of statutory immunity by the legislature, it needs to be strictly and narrowly interpreted. So that is the case. The Whistleblower Act needs to be strictly and narrowly interpreted. Moreover,
Are we stuck, notwithstanding the definition that we just talked about, are we stuck with the definition of agency liability that was included without objection in the jury charge?
No, Your Honor. This issue was raised 5 times below. 3 of the times it was raised was prior to the charging of the jury. It was raised on a motion for summary judgment. It was raised on motion for directed verdict. It was raised on renewed motion for directed verdict. It was then raised in a motion for JNOV, as well as in a motion for new trial. So we alerted Judge Hoffman in the trial court to this in every way that we could. He had 3 times ruled against us on the applicability of the Whistleblower Act before the jury was ever charged. And because it is a waiver of sovereign immunity, that goes to subject matter jurisdiction, and there can be no waiver of subject matter jurisdiction. Justice Mohlberg expressed some displeasure in the majority opinion below that we raised this as a motion for summary judgment rather than a plea to the jurisdiction. It's 6 one way, it's half dozen the other. And he couldn't find waiver as much as he might have liked to because subject matter jurisdiction can't be waived. So even if we should have titled that motion for summary judgment plea to the jurisdiction and motion for summary judgment, as was the case, I believe, in the Pridgeon case from this court in 2022, as was the case, I believe, in the Rodriguez case from this court in 2020, it does not matter. We raised the inapplicability of the Whistleblower Act to the actions of Councilmember Briggs, and there's been no waiver of that, and it is indeed unwaivable. Your Honors, I don't think we're here to discuss the facts of this case, but to the extent that we are, it's Rodriguez 2.0. This court's opinion 3 years ago in Office of the Attorney General versus Rodriguez controls, because on this record, there is not legally sufficient evidence to show but for causation of this termination. Mr. Heilman, the city manager who made the termination decision, and his assistant, Mr. Langley, were unaware of the underlying report. They can't have a retaliatory motive if they're unaware of the report. I see my red light is on. Unless there are any questions, I will yield at this time.
Any other questions? Thank you, Mr. Kratovil. We'll hear from the respondents.
May it please the court, Mr. Roberson will present argument for the respondents.
Mr. Chief Justice, members of the court, may it please the court. Just like original sin, corruption and mismanagement in government are unavoidable. Our founding fathers set up a constitutional structure over 200 years ago that recognizes that with systems of checks and balances. In 1983, the Texas legislature and the Texas governor, through enacting a law with checks and balances, decided that one of the ways we're going to handle the problem of government mismanagement is through the Texas Whistleblower Act. Now, I stand here today and I appreciate my co-counsel at trial and managing partner being with me, and Mike Grimm, one of my clients, being here. We want justice in this case, but we also know that you want to set up a structure so that we can prevent mismanagement in government, just like the legislature did. Now, I'm going to take the order slightly different than my opposing counsel and former colleague did, because the issue of causation doesn't require you to adopt new law. I'm going to handle that first. And because the issue of what does the Whistleblower Act mean when we say by an employing governmental entity, by a governmental entity, and I'm going to address that second. First of all,
If the goal of this legislation were to root out public corruption under all circumstances, as you're sort of suggesting, why wouldn't they have said something like violation of law related to the government's activities, or a violation of law concerning public matters? Or there are many ways to have written this that were far broader in terms of who's violating the law and what's the nature of the violation of law, and they chose to put in the statute what appear to be these limiting words, by the government entity or a public employee.
yes, Your Honor, they did, and they did it to give guidance, and that guidance makes great public policy sense. I'm not asking you to add words, I'm actually asking you not to let them add words. The reason the law was passed, and the reason the law is set up with a structure, the structure says report a violation of law. By the way, it defines law to include not just criminal law, not just civil law, any statute, any rule, any regulation, by the state, by a local, by a federal. We don't want to have mismanaged government, so if you're violating a law, that's the first thing we look for. Here, the law we've identified is the Public Information Act. So boom, we violated a law. Now the next question, by an employee of the government. My clients were employees at the city of Denton, so they're covered in that way. Now, what law do they have to, what law do they report? They have to report a law that was violated by an employee. We admit, because it's the facts, Miss Briggs, like literally thousands of people throughout the state of Texas. For example, the Housing Authority versus El Paso case, one of the cases we relied on, one of the cases that opposing counsel relied on prior to trial and during their summary judgment motion and in their post-trial motion. There are 401, this court can take judicial notice, there are 401 housing authorities throughout this state. They are governed by volunteers. Now, when the legislature passed the Whistleblower Act in 1983, under construction for statutory analysis, they assumed the laws of the land when they used the words by an employing governmental entity. They adopted the law of agency. Cities can't act on their own. They act through agents. So the question is, under the law of agency, which is incorporated in the Texas Tort Claims Act, it's incorporated in Texas criminal law, was Ms. Briggs acting as the city of Denton when she released this information to the Denton Record Chronicle in violation of the Public Information Act?
How do you respond to the argument that she was acting in her legislative capacity and your clients were employed by sort of what is the executive branch of the municipality? In other words, they report to the city manager, she's over here in the lawmaking area, and was not directly their supervisor or their employer.
Well,
So it'd be like a member of the judicial branch reporting a violation of a single state representative, for example.
Your Honor, I don't find anything in the text, history, or purposes of the Whistleblower Act that makes that distinction. As this court
So
said,
the violation of law does not have to be by a state official within the same branch of government or the same department or anything like that.
well, we're not talking about a cross-governmental item. There might be an issue, and I haven't researched it, quite frankly, Your Honor. If someone who works for the city of Dallas wanted to come up here and turn in someone who works at the Texas Rangers, I'd have to research that, Your Honor. We just don't have that here. Here, we have people that are working within the city of Denton. What happened was my clients, they found, opened up this Denton Record Chronicle report. It had scores and scores of documents attached. They looked at the documents. They're like, holy cow, this is illegal. We're going to get sued. We better call the city attorney's office. They called the city attorney's office within 4 hours. The newspaper shut it down. Because of that, they weren't sued. Everybody was happy. The city attorney was happy. The council was happy. The city manager was happy. But what happened? They all left. We get a new city manager, a new city attorney, new assistant city managers, and Miss Briggs, the one who illegally reported this information to the Denton Record Chronicle, she becomes the leader of the group that takes over the city council. So she's in the same organization, she violated the law, and she didn't just do it on her own. First of all, it's official misconduct under the PA Public Information Act. This isn't some joyride. She wasn't driving drunk. It wasn't like the Johnson case where the guy was dealing drugs. It's official misconduct. Number two, she didn't do it alone. With all due respect to opposing counsel, she did it with another city council member. Number three, she didn't do it for personal purposes. Now, this is very important, Your Honors.
What's your best argument that she has authority to act for the city of Denton?
Well, there's multiple, both factual and legal, Your Honor. I'll start with factual.
Let's start with legal.
Legal, all right.
Well, what is her legal authority to act for the city of Denton?
Right. Under the local government code, Your Honor, any statements by a city council member made on Facebook, made on any other social media, it's not that the local government code says that that's not allowed. It says if you comment as a city council member on social media about the work you're doing as a city council member, that belongs to the state. You can't destroy it. So as a matter of law, it's recognized that city council members talk, and it's recognized that they talk about work. Now, here, Denton has done a couple of things factually. First of all, they have given talking points to city council members. They not only know that city council members are allowed to talk about what they do, they help them talk. And there are talking points inside the records of this case. And I can file a post-argument brief if you want to find you that pinpoint site. But she also did it with another city council person, Councilmember Bergeri. And the concept that we think city council members don't talk is a concept that's factually divorced from the reality of city government in every city in this state. City council members talk. They talk about what they do. They go out and they try and do things.
The question is, who are they talking and acting on behalf of? The
Well-
city as an entity or themselves as council members and politicians?
Well, let's take a look about what the record says here. In regards to Ms. Briggs and Ms. Brigari, they both said, it's in the record, that the reason they were doing this was because of the public trust. Ms. Briggs stated on the record, "I just wanted everyone to see what I would see because citizens have a right to transparency." She said she wanted to protect the city, the residents, and the ratepayers. This was a $250 million contract to create a new power plant. She thought it was wrong. She was trying to get the vote stopped, and she succeeded. The vote was stopped for 7 days so that the other city council members could look at these documents that had been released to the Denton Record Chronicle. So not only was she doing it for a public purpose, she succeeded until the other members of the city council took a look at the documents and said, "No, there's nothing wrong here. What are you talking about?" And it was voted down 4-3. And quite frankly, Mr. Grimm and Mr. Maynard wouldn't have been fired if the city council hadn't changed. But
So that's a question then. Were they fired because of the report that they had made a year earlier, or fired because there was a change in leadership that decided to go a different direction? And obviously they have the results of the investigation that they rely on to justify the termination. So what evidence is there connecting the report of public disclosure to the firing a year later?
Well, Your Honor, I appreciate that question greatly. And the way the court should analyze it is under the cases that have previously set out 6 different factors. As this court has previously said, because smoking guns are hard to come by, in retaliation and discrimination cases, plaintiffs have to rely on circumstantial evidence. Now, quite frankly, one of those elements is if the explanation of the employing authority is unworthy of credence, to quote Justice Scalia. In this, there are 6 different factors under Zimlick. 5 of those factors come from Continental Coffee versus Cazares. Zimlick and then later Rodriguez have added a 6th factor, and that is temporal proximity. Now, the fact of the matter is we have circumstantial on all but one of those 6 factors. In Zimlick and in other cases decided by this court, there's been no requirement that you have to have 5 of 6, 4 of 6, 3 of 6, 2 of 6. There have been cases from this court that just 1 or 2 of 6 is sufficient. We have strong circumstantial evidence on all but one of them.
So the city contends that the new city manager was unaware that your clients had made this report. Is there evidence that indicates that the new city manager, in fact, was aware that your clients had made the report?
Well, Your Honor, his personal awareness is only one of those 6 factors. The fact of the matter is he testified he didn't know. But his testimony is unworthy of credence, and there's no way for me to get inside of his brain, which is why smoking guns are hard to find. Now let's take a look about what he did testify as to what his knowledge was. He said, so this occurred in September. He joins in January. When he joins in January, he's briefed on the leak by the city attorney, the person to whom my clients blew the whistle to. He was also briefed by the mayor. Now, he said, it never came up. We never talked about it. The jury can decide based on what they saw in the courtroom that that's unworthy of credence. Now, if he did know and didn't tell the truth, and there's substantial evidence in this record, Your Honors, that neither he nor Mr. Langley nor Mr. Briggs were giving credible evidence at all. I mean, Mr. Langley said when I was cross-examining him 87 times in 120 pages, I don't know. And, it's not part of the record, but when I mentioned this in closing arguments, the jury laughed. They knew that he was obfuscating. The record shows, more importantly, that in regards to Mr. Heilman, he was very politically astute, yet he claimed not to be. Here's how we know he was politically astute.
Can I stop? There was an election that took place at some point?
Yes, sir.
And this all arose from a political testy political fight in city of Denton politics, and then Ms. Briggs's side won the next election.
Yes.
Yeah, and I wonder if it seems to me to flip almost entirely the sort of equities of the situation. I mean, the people of Denton are presented with this this conflict between these two visions of, competing on the city council. They choose hers, and then the new city council elects a new city manager that doesn't want to keep around the people who were sort of entrenched on the side that lost the election, within the bureaucracy, and so lets those people go because they're too closely connected to this previous view that sort of failed in the election and that the people don't want to pursue. I mean that seems to be a normal and natural consequence of an election that has a sort of a political turnover of governance like this.
Well, Your Honor, first of all, I don't have to show that there was no politics involved. I just have to show that the whistleblowing was at least a part of the reason. Now, how do we do that? There's 6 ways that we can do that under Zemlick, Cazares, and Rodriguez. Under 4 of those items, we can have hard evidence that's uncontroverted. Under the 5th item, if there's controversy. Under the 6th item, we admit we have no evidence. What are those items? First of all, a failure to adhere to rules. Under the Denton City Charter, the City Council is not supposed to interfere. The evidence that the jury was presented by 2 current employees was that an assistant city manager told them at a meeting that, quote, the council members got the heads on pikes they wanted. All right, so the council was controlling. Now, Ms. Briggs, Mr. Heilman, Mr. Langley, they all denied it, but that denial was unworthy of credence. Second, Your
and
Honor,
I get the point that in terms of the statute, the fact that there was political turnover is not a defense to a whistleblower claim, but it does highlight the tension in which the Whistleblower Act exists relative to the executive branches or the legislative branch's ability to control the government in response to votes of the people.
Well, Your Honor,
so I wonder whether we've said things before like the act should be interpreted broadly to pursue its purposes of rooting out public corruption. I wonder whether, we shouldn't apply any presumption probably, but if we were to apply a presumption in interpreting the Whistleblower Act, I think we ought to be concerned with the kind of thing that happened here, where the act is used as a shield by the bureaucracy to forestall the ability of elected officials to hire and fire within the bureaucracy such that the bureaucracy's views reflect the views of the voters.
Well, Your Honor, quite frankly, the record doesn't support that view because the number 1 person at the Denton Municipal Electricity, Mr. Williams, he was let go. His life wasn't destroyed. My clients, they were fired and humiliated publicly. Now, this so-called investigation that was an honest investigation, it started out with a request to look at emails that only had 2 names, the whistleblowers' names. On March 31st, there was a meeting 6 weeks prior to the election. The city manager said, the city council has changed, past tense. He admitted that day was the day he started the investigation. He admitted that the investigation started with an email search, and that email search was Grimm, Maynard, Project Rice, and the names of the contractors. Not his boss. They weren't changing over the whole DME. Not number 4, the guy who was helping them build this new plant. Number 2 and number 3, the whistleblowers. Now, that's some evidence that he knew who he was looking for. Additionally, they were treated differently at the end. Williams was allowed to leave. My clients were dragged through the mud. They were fired, they were humiliated, their careers were ended in the public utility sector. Next, the timing of the termination. Quite remarkable, just quite remarkable. Within the time frame, Mr. Heilman admits as soon as he arrived, people were telling him about Maynard and Grimm. As soon as he arrived, he didn't ask, well, what side do you support? Who do you support? Now, he comes up with this idea that the city council is going to change, but when we asked him, well, how'd you do that? He said, and you all have been to candidate forums, you run for judge. It's like there were 7 candidate forums. He said he didn't go to him, he wasn't following it, but yet by March 31st, he knew the council had changed. Now, within 66 days of the election, my clients were fired, but the other leadership at DME were not fired. They were handpicked. They were treated differently. And more than that, the reason that Mr. Grimm was fired was completely false. On the investigative tape, Mr. Langley said, point blank, do you remember that March 31st meeting? Do you remember he said, oh, maybe, and this is all about a fish. I'm sorry to bring up a fish, but my client went fishing totally legally with a contractor well prior to the bidding quiet period. And they were alleged to have been asked a question on the March 31st meeting. My client's copious notes, nothing about the fish. On the tape, he said, nope, don't remember that. By the way, Mr. Williams also didn't remember it. He wasn't fired. And Mr. Langley said, well, yeah, don't you remember we kind of talked about it? And you kind of said, my time's almost up. I apologize if I may finish answering.
You may finish.
He kind of said, well, maybe there was a fish, maybe there wasn't a fish. And then in front of the jury, and Mr. Heilman was at this meeting as well, Mr. Heilman and Mr. Langley both swore under oath, oh, the denial was vehement. And the jury saw the tape transcript. Maybe we talked about it.
Can I just ask you before you sit down, does it make any difference to us that what the whistle was blowing was not the identity of the leaker? I mean, the newspaper openly said who leaked the documents. The blowing of the whistle, as I understand it, was the legal conclusions by your clients about what the legal consequences of that would be. Am I correct in that?
You are correct, and the answer is found in the Pridgeon case, Your Honor. The identity of the documents was known and was in the article. The fact
She was not hiding that she was the leaker.
She was not hiding that she
openly
was the
saying-
leaker, but new fact, not new opinion, new fact, my clients read the documents. Within the documents, there were things that the city could be sued upon because they violated the Public Information Act. And the Public Information Act, Your Honor, if I may, in concluding this answer, is not something to be taken lightly. There are only 3 or 4 major manufacturers of electrical turbine engines in the world. And if they can't trust the city of Denton to keep their trade secret secret, then some of them might not bid for the next contract to build a public utility plant in Texas.
Do you have reason to think that would not have been something that the city attorney would not have concluded himself, regardless of whether people read the article before he sees it and says that?
Your Honor,
And it seems like a kind of basic point to me, but maybe it's not.
I don't think it is. And a couple of reasons why I don't think it is that these are highly technical pieces of information. Now, I come from a scientific background. I might have been able to find it, but I know a lot of attorneys wouldn't. Quite frankly, in this case, there was testimony that members of the city of Denton didn't even know the difference between a natural gas power plant and a coal power plant.
There were provisions of these documents in which the city had agreed not to disclose them, right?
Yes, Your Honor.
The city attorney would not have known that?
The city attorney would not have known what technical details and what technical specs were in violation of the Public Information Act. As a matter of fact, the record before the court and before the jury was that the assistant city attorney had gone through these documents. Ms. Briggs had asked for them in her scope as a city council member. And the assistant city attorney had gone through the documents, had marked one stack confidential, and had marked another stack not confidential. Ms. Briggs then went through the stack marked not confidential, removed a bunch of things, blacked out a bunch of other things, but still missed these things that would have gotten the city sued. And more importantly, I believe the thing that got the city not sued was the timing of it. It wasn't up long enough for GE to download Wärtsilä's plans. It wasn't up long enough for any other competitor to get a competitive disadvantage. And that's why, in the end, Your Honor, I believe that my clients, under the text, the purpose, the history of the act, they should prevail. And in closing, just 10 seconds if I may, this court should adopt the Johnson and the Rangel opinion. We didn't come up with this. This is what both sides argued at the trial court should apply. Only after at the Court of Appeals did we first talk about anything else. We think Johnson and Rangel are good law. We think that it supports the text, purpose, and history of the Whistleblower Act, and I thank you for your time, Your Honors.
Any other questions? Thank you, Mr. Roberson. Mr. Kratovil, you have 5 minutes.
Thank you, Your Honor. Your Honors, I stand here in a fairly extraordinary position in rebuttal argument and oral argument on the merits before the Texas Supreme Court, armed with legions of briefs and an almost 40-page majority opinion from the Dallas Court of Appeals by Justice Mulberg. And at this point, I still don't understand the argument that Keely Briggs is the city of Denton. For that is what she must be for there to be liability against the city of Denton. They've conceded, and we've established, she's not a public employee. So under the plain statutory text adopted by the legislature, if she is not the same thing as the city of Denton, she is not, they are not liable. The Whistleblower Act doesn't apply. We've just heard an awful lot about facts, policy, maybe a little statutory history, maybe a little equity, but what we didn't hear much about was statutory language, and that's what controls here. I heard no defense of the expansive test that the Dallas Court of Appeals created from whole cloth for the application of the Whistleblower Act. And that whole cloth new test is if it relates to or is in the public interest, then the actions of an individual, volunteer, elected official are suddenly covered by the Whistleblower Act. That is incompatible with the text of the Whistleblower Act. I think it's extraordinary that my old colleague and friend and mentor made no effort to defend the opinion below in the test it articulates.
If the city of Denton provided in their budget an administrative assistant for Councilmember Briggs, and one of the clients in this case had been her administrative assistant, would you still say that the Whistleblower Act did not apply to her, to their report?
If there were complaints about the actions of another public employee, in this case that assistant, then that probably brings us within the
I'm
Whistleblower
saying
Act.
they are in the role, they work directly for Councilmember Briggs. They work for the city council, they work for an individual council member. Would the Whistleblower Act not apply to a report of unlawful conduct by their boss?
So I think the answer to that is found in this court's Pope decision. And the answer is if there is a specific report about specific misconduct by another public employee, which could be that.
Well, your position is that Councilmember Briggs is not a public employee because she's not in paid service of the government. So, but the person that reports to her is in paid service. They're a staffer for the council member.
And if that person engaged in misconduct, then that could be within the Whistleblower Act.
But
that
not
is
if
not
their
this
boss
case.
did.
Well, if her boss was acting with authority granted to her by the city of Denton, then yes, that would be an act of the city. Again, I think it's that Pope test by the governmental entity.
So providing confidential documents to an individual council member for her, in connection with her review of an ongoing vendor selection process, doesn't put her within the ambit of doing work for the city of Denton.
I don't believe it puts her within the ambit of this statute and its express language that must be construed narrowly and strictly because it's a waiver of sovereign immunity and because it's a cause of action not found at common law. For those two reasons, this statute, the Whistleblower Act, has to be construed narrowly and strictly. The Court of Appeals has done the opposite and construed it expansively. And respondents ask that you do the same and construe it expansively straight wide. That's just incorrect as a matter of statutory interpretation. And again, we've heard some good policy arguments, and I think Your Honor's articulating a good policy arguments. Those policy arguments are for the elected branches. If there needs to be an amendment of this statute, about a year from now, the legislature will be back in session. That's just not the role of this court when the legislature has legislated with clarity and with a lack of ambiguity. Finally, we heard that detailed factual discussion, but we heard no mention of this court's most recent controlling precedent on legal sufficiency in the whistleblower context, Rodriguez. And I'd suggest the reason we didn't hear about Rodriguez is that this record doesn't get us to what Rodriguez requires, which is showing that the decision maker or decision makers, plural, acted with retaliatory motive. That is this court's language, not my language. When Mr. Heilman, the city manager, Mr. Langley, the deputy city manager, were unaware of the report, they can't have acted with retaliatory animus. I thank the court for its time.
Any other questions? Thank you, Mr. Kratovil. Case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.